This is A New Angle, a show about cool people doing awesome things in and around Montana. I'm your host, Justin Angle. This show is supported by First Security Bank, Blackfoot Communications, and the University of Montana College of Business. Hey folks, welcome back, and thanks for tuning in. Today, I am speaking with University of Montana law professor Craig Cowie about a series of landmark decisions made during this year's Supreme Court session.
In an issue of presidential immunity, we're talking about what's our framework. Is our framework that the president is a person who is subject to criminal laws that apply to everyone, or is the president not that?
The court's rulings on presidential immunity, as well as Chevron deference, are complex and have a wide variety of implications. Craig will help us better understand what this all means for us and our country. Craig, thanks for joining me.
Thanks, Justin. Great to be here, as always.
Yeah, so you've been on the show before, but remind listeners, where did you grow up and what did your parents do?
I grew up in Ohio, and in northern Ohio, just on the border with Michigan. And my dad ran an advertising agency, a local advertising agency that handled sort of local businesses. And my mom was a first grade school teacher, plus later in her career, she ended up being a social worker.
Okay, so let's start with the presidential immunity case. But before we get into the details of the case, just what is immunity? It's a word we throw around, we hear a lot, but what does it actually mean?
It's immunity from any kind of criminal prosecution or even investigation. If the president is immune for certain acts, that just means they're off limits, even if they would otherwise be unlawful.
So why is it useful for a president to have some form of immunity?
The arguments around president is that it's such a unique position with powers in our Constitution, and we want the president to be able to use those powers, vigorously, but lawfully. And one concern is that if they could be sued, there would be sort of harassment suits, and they'd be worried about constantly looking over their shoulder, or am I going to be sued or prosecuted in this case, criminally for actions I took when I was president. And the president has to make a lot of judgment and policy calls at a high level. And so some people argue that we don't want them to have to look over their shoulders always, because that's going to inhibit them from actually doing the job we want them to do.
So is there like a standard example that you law professors use in class to demonstrate like why it actually makes sense?
Not really. It's funny because this hasn't really been an issue before at the level of this case. So this is what we call a case of first impression, which means the court hadn't really ruled on it before. But a lot of, I'll give you a counterexample, which is Watergate.
Yeah. If the president does it, it's not a crime.
Exactly. That was President Nixon's, position. And at the time, the courts didn't follow that. Right? That was not, they don't really explicitly reject it, but that's what, as a result, he's not. And of course, there is all sorts of investigations. Coming out of that, these things were all really important, and people thought that the president actually isn't necessarily immune. But if you think about it, for example, the president orders the assassination of Osama bin Laden, right? And SEAL Team 6 goes and kills him. So that's a killing, and it's authorized by law. But could somebody decide that they wanted to sue that or claim that that was murder? Maybe they could. Maybe somebody on the other side of the aisle down the line might look back and say, oh, I'm going to take my Department of Justice and go after that president for what they did.
Okay.
And then there might be like a tit for tat. That certainly seems to be something that Chief Justice Roberts was worried about in the decision, was this idea that we don't want current presidents going after past presidents.
Sure. Okay, so we might as well pivot and get into the decision.
Sure.
Trump versus the United States. Give us the breakdown. What's the case about, and then what did the court do?
Just at a high level, these are the prosecutions related to the January 6th events. And the claim is that President Trump interfered with the process for certifying the election.
Okay.
And that's a crime. And there's 4 different charges that they bring that are all sort of circling around that. Those are all federal crimes. And President Trump argued as part of this prosecution, that he was actually immune because he did these acts while he was president. And the court didn't agree, so it doesn't rule on whether or not President Trump is immune. But what they did is they said the lower court used the wrong framework.
Okay.
And they created essentially a three-part framework. So for core acts, things that are just within the heart of the president's powers under the Constitution, there's absolute immunity. No prosecution, no investigation. For the other official acts, so sometimes called peripheral acts, there's what the court called presumptive immunity, which means there's a presumption that the president is immune, but prosecutors can rebut that. And then for unofficial acts, the court said there's no immunity whatsoever. One other important caveat of the decision is that in addition to those three categories, they did another thing, which is they said you can't use evidence of official acts in the prosecution of a crime, and you can't consider the president's motive. So even if something is immune, and so you can't prosecute it, but there might be some illegal activity related to that, you're not going to be able to talk about the immune act.
What are classic examples within those three categories, and what are maybe some edge cases that we need to think about?
So the core is pretty straightforward. You think about things like the military, commanding the military, pardons expressly stated in the Constitution, also the investigation and prosecution of crimes with the Department of Justice. And that's a big part of what the executive's power is. They enforce the laws. And so that's a core power as well.
Okay. So that explains core powers.
Mm-hmm.
Now this next level.
The periphery of official acts is kind of everything else that the president might be authorized to do. And here, if you think about core, is oftentimes those things that I mentioned were all things that the Constitution gives solely to the president and to the executive. Like only the president does pardons. Congress doesn't do pardons. But there's lots of powers that Congress and the executive share. And so we think about those might be more like they're still official acts, but because the power isn't solely the president's, maybe they're more periphery than core. It's a pretty expansive definition of official acts according to the majority in the case, because it's anything that is not manifestly or palpably beyond the president's powers. So it's a very expansive definition.
You mentioned conversations with the vice president.
Mm-hmm.
Let's just do a little sort of review of the case. So some form of conversation was alleged to have taken place between the president and the vice president prior to the January 6th certification of the election?
In a nutshell, the original indictment claimed that the president tried to both use the Department of Justice to pressure states and also the vice president, who is also the president. As part of the vice president's duties, the vice president is the president of the Senate. So that's why Vice President Harris is casting tie-breaking votes.
Sure.
And part of that duty is to sit over the certification of electors process, which is what was happening on January 6th. And there, the question is the vice president acting as part of the executive?
Yeah.
Or is he operating as part of Congress? And the answer to that question will influence whether or not, under the court's framework, the president is entitled for immunity. Basically, the discussions with the Department of Justice and trying to pressure, the states to change their slates of electors so that President Trump would have won the election, that's part of the core.
That's off limits to prosecution.
So that's off limits to
complete immunity
prosecution.
there.
Yep.
Okay.
And when, after this case came down, the prosecutors issued what's called a superseding indictment. So that's just a new indictment to reflect this. And they took out the references to the discussions with the Department of Justice. They took out an unindicted co-conspirator who was an official in the Department of Justice. But interestingly, they left in the discussions with Vice President Pence, but being very clear that they were talking about Pence's role as president of the Senate. And they were characterizing what President Trump's discussions with Vice President Pence were actually about Pence's legislative duties.
In the indictment, they conceive of Pence as part of the legislative branch. And so Trump is abusing his power by trying to influence the legislative branch unduly. Is that a correct?
Whether or not abuse, that goes to like maybe the merits of the charges being brought by...
Which the court did not rule on, right?
Right. No. Instead, but what that does is that raises the question of, so there's presumptive immunity for the discussions with Vice President Pence.
Got it.
As Vice President in the executive, but the prosecutor in that case, Jack Smith, is making the argument that when Vice President Pence is acting as he was on that day as president of the Senate, that's not an official act. He's going to try and frame that as an unofficial act for which the president's not entitled to immunity, and therefore can be prosecuted if his conduct violated the law.
Trying to interface with the Department of Justice to influence the certification of state-level elections. That's considered part of core power. What about President Trump's alleged sort of communications directly with states? Is that part of a core power in this context?
So that's going to be a big issue that they fight about, but the answer seems to be no. And certainly the way the prosecutor is framing it is that when the president has no role in how states determine what their electors are.
Sure.
And therefore, when the president communicates with states about how they're setting their slate of electors and who they're going to put forth, that's not an official act. Now, President Trump's going to dispute that, and he's going to say, no, everything I say as president is part of the presidential act. And presidential communications, including with the public, are sort of in that presumptive category of other official acts. So it'll be interesting to see how they frame these issues up. And that's going to be a constant theme for us as we're talking about this last term, is that how you frame these questions is now very important. So if you frame it up as a question of whether or not the president can pardon someone, that very clearly seems to be a core. If you frame the question as, can the president accept a bribe to pardon someone? A quid pro quo, if you will. I'll pay you this money, you give me the pardon. Does the president have power to accept a bribe? Well, that doesn't seem like that's an official act. And in fact, former Attorney General Barr, who was one of Trump's attorneys general, he said, no, the president doesn't have any kind of power to accept bribes. And so we said, that's not an issue. People are being like hyperbolic.
Did this hypothetical come up in the text of the decision?
The bribery, I don't know if the bribery did exactly, but it's certainly an example that's been bandied about.
Yeah.
And it's a really important one because, as I mentioned, the Watergate case involved something that looked, the milk fund scandal was essentially a bribery claim and, a quid pro quo payment for official action. And if it's protected, then, I don't see how a prosecutor can get at that bribery. So let's assume the bribe happened. So there's a straight up, I want you to president my brother, and so I'm going to give you $100,000 to the president. And the president's like, okay, sure. And then they issue a pardon. So assuming that happened, that does seem to fit the notion of bribery,
sure,
if somebody other than the president had done it. And then the question is, okay, pardon's a core act. So is the act, the pardon? In which case, despite what former Attorney General Barr said, it's off the table. But let's say it's on the table even. There's a bigger problem, which is that evidentiary issue I mentioned at the beginning.
Let's come back to that.
So now, let's say you've got a bribery. Well, in the classic bribery case, you have your quid and your quo, right? Your quid pro quo. Somebody makes an offer of something, so you can talk about that. But what you can't talk about is, did they actually do the pardon? The pardon's an official act, so you're not allowed to introduce evidence of that in a criminal prosecution. And you can't go into the motive. So, which is mens rea, which is your mental state.
You need that to prove a crime.
You need that to prove any crime.
Yeah.
And certainly when you talk about bribery, what you're talking about is somebody taking an official action for an improper purpose. And it becomes very difficult for me to see how you effectively prosecute bribery, even if you can prosecute it at all under this framework.
Sure.
So let's say the president orders someone, a political rival, to be killed. And some people have said that the dissent raises this. This came up at oral argument, and the dissent raises it very strongly in the opinion. And people have said, they've sort of poo-pooed that and said, oh, you're just, that's never going to happen. That's beyond the power. And the problem is the opinion itself is quite broad and quite vague. It doesn't give us tons of details about what falls where and how we would actually prosecute these crimes afterwards. And so as a result, I don't think it's fair to call it hyperbolic. It's a real question. I hope that would never happen.
Sure.
And I'd hope that we could prosecute a president who abused their power in that way. And I would hope that the people that the president asked or ordered to do that would object and refuse to do so because, on their own moral grounds. And, with this opinion, I can't say for sure that. So I think it's a legitimate question.
We'll be back to my conversation with Craig Cowie after this short break. A New Angle is proudly presented by First Security Bank, Blackfoot Communications, and the University of Montana College of Business. This show does not happen without these pillars of our community, and I'm so grateful for their support and encouragement. And speaking of support, have you checked out our new website yet? anewanglepodcast.com. There you can support our show directly with a variety of subscription options. Subscribers get access to bonus episodes, additional segments, writings, and other benefits. So check it out at anewanglepodcast.com.
I'm Maureen Dowd of the New York Times, and you're listening to A New Angle.
Welcome back to A New Angle. I'm speaking with law professor Craig Cowie about the Supreme Court's ruling on presidential immunity. Trump brings this case. It works its way up through the courts. Make the case, the court has to deal with it.
Yes.
Right? And so as judicial rule or Supreme Court rulings go, is this sort of the way the system is supposed to work, that they put out a framework that has some vagueness to it and then it has to get litigated over time to fill in the blanks? How is this actually, how is it supposed to work, and is what we're observing here in line with what a normal process could be?
There are times when the court does just announce a framework and we sort of build it out in the lower courts and develop it based on sort of a case-by-case analysis. And we're going to see that in this case because right now, in a couple of days, the prosecutor is set to file a brief with the judge in the January 6th case explaining why he thinks these criminal charges can go forward despite the Trump versus United States ruling. And then President Trump will respond. And then the court will have to grapple with the issue. But when the court issues such a broad ruling, though, we do hope that it would give us some indication of how we should analyze these questions and how will this work. And in certain respects, one could say, well, the court didn't need to do all of this right now in this case. There was precedent. People certainly thought that President Nixon could have been prosecuted for what happened in Watergate, and the events of the investigation into that conduct are what led to his resignation.
Right. And so he resigned.
Yes.
And then he was pardoned by Gerald Ford. So there was no need for prosecution at that point.
There are examples all the way back, like Jefferson was ordered to produce documents related to Aaron Burr, in investigation of his conduct. So, there's a long history of that. But I do think that in something as important as presidential immunity, I think it would have behooved the court to give us a little bit more details on the framework so that people aren't asking the question that we're talking about today, so is bribery okay? Is assassination okay? And the opinion, those were the assassination came up in oral argument, and there was discussion about it, and so the court could have addressed it, but it didn't in the majority, and so we're just sort of left to wonder. And in an issue of presidential immunity, we're talking about what's our framework? Is our framework that the president is a person who is subject to criminal laws that apply to everyone, or is the president not that? So under this ruling, the president is clearly not that in some sense. The dissent argues that what you've done is it's so broad and so vague that you've made the president king.
So what is the move that's being made in that argument? Are they saying that that sort of fourth clause that you described about not being able to use the evidence of the act, is that sort of the get out of jail free card that supersedes all of the unofficial acts?
Again, it's a question of framing. And so for the majority is like, look, we need to protect the president from being second guessed and from looking over his or her shoulder when exercising presidential powers that we want them to exercise. The dissent frames it up differently, and it says, look, the rule has always been that the president's a person and is therefore presumptively subject to all the criminal laws, and maybe there's some immunity for certain actions because and we have doctrines of immunity in other areas like that for that reason. But the dissent says, well, what the majority's done is they've flipped that presumption on its head, because now the presumption is the president's just absolutely immune for whatever the president does. Basically going back to what you started with President Nixon, like if the president says it,
correct,
it's legal, or the president does it, it's legal. And from their perspective, that's a risky move, because you think about all the discretion a president does have and all these questions, and we're just not going to get any clarity.
I think one of the things that has come up over the last 7 or 8 years has been some things in our system rely on law and some things rely on norms. And so this decision, some of the vagueness relies on some existing norms to hold, I would presume. How, from a legal scholarship standpoint, how do you think about this distinction between laws and norms?
The fact is that the norms are just that. They're norms. So we have a norm, but if you break a norm, there's no consequence.
Right.
If you break a law, there's a consequence. And so,
or maybe not in this case.
Well, exactly. Yeah. And that's the thing. And so when we rely on norms, what we're relying on is people to act in the country's best interest rather than in their own interest. When we rely on laws, we've sort of decided as a society, these are the norms that we're going to put force of law behind.
Okay.
And everybody, at least that's the argument the dissent makes, everybody is subject to those. What this does is sort of fractures that and says, okay, well, for the president, we're actually going to assume that most of these laws do not apply, and you have to make a case for them applying in certain circumstances.
So at the end of the day, did the court create any new power for a president?
They didn't create any power. What's interesting here is I think what this is a shift in powers. We talk about separation of powers between the executive, which is the president, the legislature, which is Congress, and the judiciary, the courts.
Okay.
And here, what you have is a shift of power away from Congress and away, actually, I would argue, from the executive to the judiciary and to the president as a person.
Okay.
Because it is the executive's role to prosecute and investigate crimes. And what the court's done with this is said, no, we get to make that initial charging determination. We get to tell you, yes, you can charge a president with that crime, or no, you can't.
So you're arguing that this decision is actually, I don't know if power grab is quite the right word, but like the judiciary is claiming some power that it didn't really have before.
Yeah, I think that's absolutely right. If you think about it, like Congress sets the laws, and so Congress passes our criminal laws, or at least our federal criminal laws, and they tell us who these apply to and what conditions and all that. And the courts just interpret that, and they sort of make sure you get a fair trial and some other things. But they don't second guess what should be a crime and what shouldn't be a crime.
Yeah.
They just look at what Congress has done. And now what they're saying is, well, actually for certain things, although Congress said it was a crime, we're saying that it doesn't apply to the president. And the way they're interfering with the executive is, right now the executive is prosecuting the case against President Trump. And they're doing so based on their best judgment. I think if we're going to assume good faith, right? But they've made this claim. But now what the courts are saying, well, actually, although it's ordinarily the executive who decides who to investigate, whether or not to proceed from an investigation to a criminal prosecution, because sometimes they investigate and they say, oh, there's no crime here, or we can't prove it. So that decision to prosecute is then made by them, and then they go forward, and then, the courts hold them to the fire, right? Make them follow the rules and make them prove their case. But now the court's saying, well, wait, that charging decision is actually ours. We get to look at whether or not the president can be charged with that crime. And it's based on our framework of, these core official acts or unofficial acts.
Got it.
That's shifting power from, ordinarily it would have been, the prosecutors are bringing this case and they've decided, and the court can decide, no, the law doesn't mean that, or you've interpreted improperly and this doesn't apply to this situation based on what the law says. But here they're doing that even at the beginning, and they're just saying, no, you don't even get to bring this charge. That's what immunity is. Nobody can stop you from doing what you're doing. Immunity is not a defense. Immunity means you never have to stay.
It's a hall pass.
Exactly. Yeah.
I mean, you often see it portrayed in movies as like diplomatic immunity, right? Some diplomatic, hey, I can do whatever I want. You can't do anything.
Yeah. What you can do is you could impeach a president for their actions, or you could vote them out of office.
Sure.
But
those are the two remedies.
Those are the two remedies that we have for a lot of these acts right now, even when I think, you've got people like former Attorney General Barr saying, well, yeah, the president doesn't have any power to accept bribes. Like we clearly, for official acts, that's clearly true. But the question is, that may still be true, but if you can't actually bring the prosecutions effectively, it's sort of
there's no mechanism to charge.
Yeah. It's sort of a right without a remedy.
What happens next? Because you said the court didn't rule on the merits of the case. It put out this framework, and then it gets remanded back to the lower court?
That's right. So right now, they're in front of a judge in the United States District Court for the District of Columbia, which is a trial-level court. And in that case, so they filed the superseding indictment, and it made the changes I mentioned. And the prosecutors obviously feel like that comports with the immunity decision that comes from the court. They're filing a brief on September 26th. At least that's the current deadline. That brief will make arguments about why they can still bring these 4 charges based on the evidence that's in the superseding indictment. In particular, there's going to be a fight about whether or not the communications with Vice President Pence are immune because he was acting as an executive, or not immune because he was acting as president of the Senate. President Trump will respond in writing, and then the judge will have to decide. There'll be appeal, and basically we'll be back up. So as a practical matter, there's no way we're going to see a trial in this case, certainly not before the election. And of course, if President Trump wins the election, then there's a question about whether or not he can pardon himself.
Well, Craig, thanks for helping us make sense of all this. And I look forward to our continuing conversation next week.
Sounds great. Thanks.
Stay tuned for part 2 of this Supreme Court breakdown with Professor Craig Cowie next week. Thanks for listening to A New Angle. If you like what we do and want to support us directly, please consider a subscription at anewanglepodcast.com. A New Angle is recorded at Studio 49, a generous gift from UM alums Michelle and Lauren Hansen. Our presenting sponsors are First Security Bank, Blackfoot Communications, and the University of Montana College of Business. Kelly Larson is our producer. Maddie Jordan is our production assistant. VTO, Jeff Ament, and John Wicks made our music. And Jeff Meese is our master of all things sound. Thanks a lot, and see you next time.